And thank you for joining us this morning. My name is Megan Lewis, and I'm the Public Funding Navigator for Arts Alliance Illinois. I'm excited to have you all join us for day 3 of our Arts Alliance Help Desk workshop series, Sustaining and Adapting Your Creative Business. Today's program is about a topic we know lots of folks are really talking about these days, which is the role and the impact of AI in the arts. This program, which has been made possible with support of the Illinois Department of Commerce and Economic Opportunity, was designed to help the creative sector in Illinois get established, expand, and thrive. You can check out our recordings of our past webinars in the series on the Arts Alliance YouTube channel. If you haven't had a chance already, please use the chat to introduce yourself to the panelists and your fellow creatives who are here today. We're asking if you'd like to share your name, your pronouns as you feel comfortable, where you live, and your arts practice. And for those who need ASL interpretation, we have 2 interpreters with us today. You should be able to see one on your screen right now, but if for some reason you can't see them, please use the 3 dots in the upper right of their video screen to pin them as needed. So up on the slide today is our plan for today's program. We're going to be hearing from 2 legal experts and an artist on some of the emerging opportunities, challenges, and questions about how AI is affecting the creative sector. We're definitely going to have some time at the end for question and answer, so please feel free to use the chat and the Q&A throughout the program to share any questions that you have, reactions, and thoughts. We're really looking forward to this conversation today. But before we get into the presentations, I want to take a couple of minutes to give you a quick overview of Arts Alliance Illinois, especially for those of you who may be coming to our programming for the first time. So Arts Alliance is the statewide arts advocacy organization that works to build the creative sector's power through advocacy, policy change, research, and connection to needed resources to improve the quality of life of communities across Illinois. Our members and our network spans all art disciplines across the state. Arts Alliance focuses our work in 4 main areas: civic engagement that centers artists and the creative sector, policy, organizing, and structural change to help the creative sector advocate for its interests, research to collect and disseminate the data the sector needs for advocacy, case making, and building public will, and resource navigation to help connect the sector to public funding dollars. From fighting for and winning COVID relief funding for the arts and culture sector to helping creatives navigate public funding for the arts, we're here to ensure the institutions and individuals in the arts and culture sector can thrive. And the Arts Alliance Help Desk is here to support you and connect you with resources. So if you visit our site, you can start a chat with one of our staff members, check out our running list of funding opportunities on our website, and get that critical technical support to successfully apply for public funding. And we know that creatives in downstate Illinois and on the south and west sides of Chicago face disproportionate barriers to accessing the resources they need. So we're here to connect you with the experts and Illinois' creative community to make sure that all of us can thrive. As I mentioned, our program today is the last part of our series that we're holding this year to give you the resources you need to start, grow, and sustain your creative business. As a reminder, recordings of past webinars are available on our YouTube channel. And please keep an eye out for the final part of our series on expanding your creative nonprofit, which is on September 24th and 25th. We're going to have more panelists and artists joining us. And while we've split these webinars between for-profit and nonprofit tracks, we really feel there's something for everyone in all of our programming. So without further ado, let me pass it over to Amanda and Bill, who are going to be talking about this from the legal perspective.
Technical difficulties, hold on. Alrighty. First off, I just want to thank Arts Alliance Illinois for having Bill and I talk to you about intellectual property, artificial intelligence in the arts. We are going to be covering what AI is generally, as well as just some copyright 101, which is important to understand when you're speaking about artificial intelligence. We're going to go into the legal status of where AI is, both through the Copyright Office, on the federal level, as well as upcoming legislation and government works to hopefully provide protections in this, as well as protecting your work from AI and how you can use AI and some best practices in your works. I'm Amanda. I'm an attorney at Swanson Martin and Bell here in Chicago. My practice areas are in commercial litigation, entertainment and media, and intellectual property. And we're just going to start out with an overview of what AI is, because you hear it a lot, but like, what does it actually mean? AI is defined, I guess, as a technology that enables computers and machines to simulate human learning, comprehension, problem solving, decision making, creativity, and autonomy. And AI can do a number of things, and that's seeing and identifying objects, understanding and responding to human language, learning from new experience or new information and experience, making detailed recommendations to users, and also acting independently. And when you think about independent acts of AI, you can think about like self-driving cars. So we hear a lot about generative AI, and that's kind of all the rage nowadays. And what that means in the context of AI is that it's just algorithms that can be used to create new content. And that includes audio, code, images, text, simulations, and videos. And there's several different types of models that are used in generative AI. They all work a little bit different. So we're just going to kind of go over generally what those are. When you think of ChatGPT, that's a large language model. I mean, basically, it's a neural network that is trained on large amounts of texts and data, which allow it to learn the relationship between words and then predict the next word that should appear in a given sequence. And then it can be further trained and fine-tuned on specific texts related to specialized domains. It's made it possible for computers to understand natural language inputs for tasks as opposed to code. So that includes like language, translation, sentiment analysis, text to image, and image to text. And then there's also diffusion models, and you see this a lot in images and video AI. And it's done through a process called iterative denoising. And basically, the computer uses a text prompt to understand what it has to create an image of, and then it generates random noise. And you can think of noise as kind of starting to draw a picture by randomly scribbling on a piece of paper. And then the computer uses its training data that it has to understand what features should be included in the final image, and then refines those scribbles and removes the noise at every step of the way. And eventually, in an entire new image that matches the text prompt, but hasn't already been found in the training data, is created. And then there's also generative adversarial networks, which is kind of exactly what it sounds like. So it's pitting two different algorithms against each other. One is the generator and one is the discriminator. And both are basically given the task of getting better at outperforming each other. So the generator attempts to create realistic content, and then the discriminator attempts to determine whether it is real or not. So they learn from each other to become better at their jobs, until the generator knows how to create content that is as close to as real as possible. This actually like predates ChatGPT, but it's still considered a very, very powerful tool for generating pictures, videos, texts, and sounds. And then finally, there's also neural radiance fields. This is newer. It's circa 2020. It's specifically used to create representations of 3D objects using deep learning. So it is able to create an aspect of an image that can't be seen by the camera. So let's say you have an object in the background of an image that's obscured by another object in the foreground, or the rear aspect of an object that's been in pictures from the front. So it allows a 2D image of an object to be recreated as a 3D representation that can be viewed from any angle. So think of like a ball. So on a 2D level, it's just a circle, but this generative AI program is able to kind of turn it into a 3D object, so you can turn it around and see what's on every side. It's being used a lot to create 3D worlds that are explored in simulations and video games, as well as visualizing robotics, architecture, and urban planning. So what is AI art? It's any form of digital artwork created with the assistance of AI. And humans may be involved in the AI art process by adding prompts or data, such as including like imagery, paintings, photos, print ads, cartoons, but the final creation itself is left to AI. And a sample prompt of this is retro home decor with neon lights and colors. And the AI will generate an artwork based on that description. And here's an example of what might pop up.
So while AI is a new tool that artists can use, there's a lot of discussion about how that tool interacts with the law and where the law goes now that it's got this new medium that people are creating expressive works through. And so to really have this conversation about this, we thought it was important to also say a little bit about where the law is and how it traditionally protects art and artists, and where we see all of this going. So to really have that conversation, one of the things we want to talk about is just a little bit about Copyright 101 and what a copyright is and how it is intended to protect creative works. So a copyright protects original works of authorship fixed in a tangible medium of expression. So that this is always, until now and through the present, been defined as something done by a human being. Monkeys, if they draw on a piece of paper, that's not copyrightable. So there's a similar concept that's applying to AI right now, where if it's done solely by a computer, is it really copyrightable or not? And so far, the answer from the US Copyright Office is no. That answer does actually change where you go in the world. If you're in China, you may get a different answer. Canada may have a different answer as well. But in the United States, the answer right now, at least, is no. One of the other questions is just kind of what is copyrightable. All right, so there's stuff we think of, every book you've ever opened in your life, the first page has got like a copyright notice on the beginning, right? Musical works, including the lyrics, those are all copyrightable. Plays, dramatic works, copyrightable. Pantomimes and choreographic works, copyrightable. There's always the dispute of like whether or not a TikTok dance is sufficiently creative to create a copyright. But for our purposes, let's consider that copyrightable. Kind of the list goes on. What we're talking about are things that are fixed in expression. And one of the important things to recognize is that once you as a human being create something like this, you actually own a copyright in it right away. You can register it with the Copyright Office, and if you do, you're going to have additional legal protections, which can be very valuable. But the reality is, once you create something, you've got that copyright in it. And so if you see copies popping up everywhere, don't sit there and go, oh, I didn't go get a copyright, I can't protect it. Go find a lawyer. Another area of copyright law that's really fun right now, in addition to AI, by the way, is tattoos. If you get a really unique tattoo, the tattoo artist may have a copyright on the thing they put on your skin, which is a really fun topic for lawyers to discuss ad nauseum, but we won't get into that today. But that is kind of like how expansive the copyright law thinks of the protections. is, if you're the one that creates the work, and in that case, it's the tattoo artist creating the work, regardless of where you put it, it's your expression, it's your thought, and that's a copyrightable thing that you can protect. So let's talk a little bit about what is not copyrightable. Ideas, facts, procedures, methods, systems, processes. Nonfiction works are difficult to copyright. You can copyright sort of the exact phrasing of a fact, perhaps, in the context of a larger book. But that fact, that knowledge, you do not have a copyright protection on that. Works not fixed in a tangible medium are not copyrightable. This creates some issues for things like video games, where the copyrightable aspects may be certain pieces of the game or certain aspects of the game. A classic example is the video game Tetris. If you remember that one, there is a copyright. Tetris holds a copyright on the size of the grid and the look of the game pieces. But if you create a different sized grid with different looking game pieces, that's fair game. And so, it's within games where you're playing and you're manipulating stuff and it's not necessarily fixed. The unfixed aspects of the game don't lend themselves very well to copyright protection. Titles, names, short phrases, and slogans also typically not copyrightable. We may have trademark protection for those. There may be other things that we can do to protect you, but that's not going to be copyrightable. Another one is familiar symbols or designs, or just sort of variations of typographic ornamentation, lettering, or coloring. If you come up with a whole new style of font, that may well be copyrightable. If you're just creating variations on sort of standard typography, however, that may not be. It's a kind of a messy area. And I want to give another example of where this all gets really messy. So if you can see this is a art piece by one of my clients, the Contemporary Art Collective, Mischief in Brooklyn, and they created a blurred out version of the $20 bill. It's effectively a statue. It's fixed medium. It's creative. It hits most of the copyrightable elements, but it is kind of on the line. Is this a familiar symbol or design? I mean, it's meant to look like a $20 bill. They acknowledge that this is stylized to look like almost like a video game rendering of money. So again, that's sort of it's evoking something very familiar, but they are doing it in a creative way. It's different. It's not within a video game. It's something else. So this is kind of right there on the line as to how the Copyright Office might handle it. So that kind of, again, I just want to give you a sense of where the line is, when it is that you want to go talk to a lawyer. Obviously, we're not here. We can't give you legal advice today on any particular problem that you have. But I do want you to come away from all of this with kind of a better sense of where the law is, how it can protect you with AI, and how it won't. Let's go on to the next slide. So let's talk a little bit about where copyright law and AI have intersected so far, and then Amanda's going to talk a lot about where we're all going. So far, as I sort of previewed, Copyright Office has drawn a pretty firm line that says a copyright can only protect the material that is the product of human creativity. They can't and they won't protect an AI-generated image. If you've worked with AI, you know that there's a lot of issues with that. And specifically, the question kind of quickly becomes, well, how much manipulation do I need to do as a human before I've created something that actually is copyrightable again, that actually is the product of my creativity? The prompts, the inputs. How detailed? Is there a point where you can be so detailed that you've basically, taken the photograph, if you will, and figured out how you want that image to be manipulated and created it yourself? Photography is the example that advocates for copyrights in AI often point to. The human aims the camera, but the actual photograph itself was not created by the human. It's created by the camera. And yet we've never had an issue in the copyright law of saying, well, since the human placed all the elements and figured out how that thing was going to be framed and what exactly the image would look like, that can be copyrightable. And so on the prompt side, the front end of the creation, how much human manipulation is enough to make that? No, that's really more like the camera scenario, where it is an image admittedly created by a mechanical device, but one that was created by the mechanical device, very, very thoroughly with human input. On the back end of that is, what happens when you have something that's created by an AI tool and then you manipulate the heck out of it. And there's certainly a line there, and it hasn't quite been tested exactly where it is, but there's certainly a line there where it says, well, you started it with an AI image, but then you took that and you manipulated it and you made it your own human expression. You've sufficiently transformed it from the original AI image into your own work of art in a fixed medium, which is copyrightable. And so those are sort of the two, outer boundaries between on where we think all of this is going, and how you can start to, reassert your rights as an artist, despite using AI and as you use AI. But again, the one thing we know for sure right now is if you just put in a few prompts and you send it into an AI generator and it spits out, say, an image, and then you try and get a copyright on that without manipulating that image, you're going to have some real challenges. It's not likely to succeed. So a couple of things I want you to take away from all of this. One is that, at the end of the day, and we're going to talk about where this is all going, but works that contain AI aren't automatically not copyrightable. So if you see a headline like that, understand that it's misleading, and that it doesn't mean that you shouldn't go talk to a lawyer and figure out what your rights are. You absolutely can use AI as a tool in the process of creating something. I see the question in the chat, what if you start off with your own image, but use AI to modify it? It's going to depend on the extent of the modification, and it's going to depend on the extent of how that AI model is sort of using your input versus what other input it's bringing in generally. And it's also going to depend on what you do afterward. Those are all going to be factors that the courts are going to consider and the Copyright Office consider. Another way to slice this pie, though, is to say, hey, maybe I've put some aspects into my work that are AI generated, but the human elements are still copyrightable. And in that way, this is a lot like a video game. In that there are aspects of video games that are absolutely copyrightable and aspects of video games that are far more gray. So if you think of a video game, the characters, in the Tetris example, the size of the grid, the look of the blocks, those are all copyrightable. But the actual gameplay itself, how you maneuver, how you move Mario across the screen, those things are all not necessarily copyrightable, absent a few exceptions, which just prove the gray. But let's, that's not the copyrightable aspect of that. You can create another, think of the game Mario Kart. You can create another racing game. There's not a copyright on racing cars against opponents, right? So, AI performs a lot like that. It's sort of the lower hanging fruit for your protection, in that aspects of what you create, even if it's merged with AI, the human creation definitely remains copyrightable. So if you think of a song, and you've got a lyrical element to the song which is generated with AI, the rest may well be copyrightable. It all may be copyrightable. But your worst case scenario is, okay, well, that one sample that I put into my song from an AI thing, that one sample is not copyrightable, and so somebody else borrows that, your legal rights are a little bit less defined. So does this mean you shouldn't use AI? No, absolutely not. You know, I think that AI is a great tool. It helps artists, it helps musicians, it helps everyone sort of generate work, be creative. But remember that at the end of the day, it's what you're bringing. It's what you're bringing, you know, with your observations, your creativity, you know, your view of the world, that really is what's going to remain copyrightable, what's going to be protected, and what's going to remain sort of unique to you, that is going to put you in a different spot. Penny, you gave me a good segue into this next slide, so thank you very much. So the question is, if you use AI to complete works of art that are 100% generated, I assume through AI, and you sell them as your own works, what, if any, are the issues, concerns selling that? There's no issues with selling it. The issue, really the only issue you have is protecting it. So if you sell an output, and you know, you've created it on your own through the AI, you've got no issues there. But if somebody else sees that and they just sort of copy it and they start selling it on their own for a few bucks less, you don't have a lot of protections there. So that's the real challenge. Similarly, you know, there's an issue with whether or not you have like an actual reproduction of something else. So courts don't necessarily believe that just because you've taken an AI image of something and that is transformative, that allows you to you know, avoid the copyright of the original holder. So, you know, let's give an example. Let's say you want to create an AI image of a Damien Hirst painting, and you create that AI image of a Damien Hirst painting, and you you know, manipulate it a few ways, but maybe not a lot, and then you just sort of make that a reproduction. The fact that you've run this Damien Hirst painting through AI and recreated it, you know, with an AI tool does not help you avoid copyright liability. Courts frown on that. They don't see that as, you know, in copyright we talk about this thing called transformation. Have you taken something and engaged in a transformative use of it? And the courts are pretty firm right now that, well, just because you run you know, a copyrighted image through a fancy new tool, that doesn't change, and then recreate the image by using the fancy new tool, that doesn't change the fact that you didn't fundamentally change the image. You didn't transform it. You haven't added really your own thoughts on it. So you have to be really careful with that. The other fun topic that we talk about a fair amount is, well, what happens if AI uses my works? And this is a bit of a mess right now, is sort of where we're going to leave this. It's currently being litigated for large AI platforms that are absorbing a ton of information, sort of broadly across the internet. So far, the courts have been very skeptical of specific copyright holders asserting claims. For the more interesting one is sort of narrower AI tools. And say you create an AI tool that's meant to create Andy Warhols. And so it studies Andy Warhol's entire portfolio and works through that. Then you have you know, then you have a kind of a live issue as to whether or not that's infringed Andy Warhol's estates and their copyright. We're going to come back to this issue a little bit in best practices on how to protect yourself, but you know, if that's a big thing for you, if you really don't want your artwork used in AI tools, just talk to a lawyer, and they can help you out. Let's talk a little bit about the legal status and some of the issues that come up though with using AI and in the protections that you do have. One of the big ones is right of publicity. So right of publicity is a law. It varies a little bit in every state that you're in, but it's a law that fundamentally protects your image, your name, your image, your likeness, the sound of your voice, which we're going to talk about in a second. And it prevents people from using that for commercial purposes. So, you know, if you have a particular style, if you're known as, you know, have a particular look, Andy Warhol, for example, and I start using AI to create Andy Warhol-esque whatever's, and that's how I'm marketing it and that's how I'm selling it, you may well have an issue. And similarly, Andy Warhol, it's a state may well be in good grounds to come after you. You also have trademark rights in your name, in your image, in your likeness, which are federally protected rights. That's the Lanham Act. And what that will do is that really protects your right as an ability to, you know, as an artist, to protect your image, your status. And so if anybody is passing off works and saying, hey, this is an Andy Warhol that I've created using AI, you know, that's another problem that you're going to have. You just kind of can't do that. And the other big and fun case to talk about really is Scarlett Johansson. So Scarlett Johansson's voice seems to have been used by an AI generator and replicated. So Scarlett Johansson's got a right of publicity in her voice. And so if you create something that sounds like Scarlett Johansson, you're going to run into a lot of legal issues. Now, I think there's an important part about that case that gets swept to the side sometimes. And that is that the AI tool at issue in that case actually sought out Scarlett Johansson and her approval to use her voice first. And then she turned it down, and then they basically recreated her voice anyway. And so that may be sort of the triggering factor that says, well, you know, Scarlett, you have a voice that sounds like a lot of people too. No, they really did try and replicate her voice, and that's going to be the issue. So a couple of things just sort of to think about here as I kind of wrap up my section and hand over to Amanda. You know, the law is evolving on this. It's not set. And this AI is a really new, fun, creative tool for people to use, but there are ways to use it where you're protected and there's ways that you're not. So Amanda, your turn.
So as Bill touched on, right of publicity is a big issue that is being talked about regarding AI, and that is largely left up to the states, whether it be by statute or common law. And currently, only 2 states have proactively protected creators from having their likeness replicated by generative AI without permission. Tennessee was the first to enact a law. It was passed in March and became effective July 1st this year, and it's called the Elvis Act. It stands for Ensuring Likeness, Voice, and Image Securities Act. And it aims to protect a musician's vocal likeness, ensure that AI tools cannot reproduce the artist's unique voices without their explicit consent, as well as hold people legally accountable for publishing or performing an artist's voice without permissions, or using technology to mimic an artist's name, photograph, voice, or general likeness without consent. Just recently, Illinois passed the AI Digital Replica Protections Act, and it has modernized Illinois' existing Right of Publicity Act, and that act was passed in 1999, and it was meant to require written consent for use of an artist's likeness or for commercial purposes. So now this allows musicians, record labels, and other rights holders to sue parties using AI to generate and disseminate unauthorized digital replicas, which in the act is defined as newly created electronic representations of the identity of an actual individual created using a computer algorithm, software tool, artificial intelligence, or other technology fixed in a sound recording or audiovisual work in which that individual did not actually perform or appear. This, again, was recently just passed, so it'll be interesting to see how that works out. Illinois also has a generative AI and natural language process task force, which was enacted through statute, and it's currently focused on developing AI best practices that ensure public safety, privacy, and fairness, right? And the task force is also exploring opportunities for the state to apply large language models, again, like ChatGPT, in the domains of public school classrooms, the workforce, and in cybersecurity. They are required to hold at least 5 public meetings and summarize the recommendations in a report shared with the governor's office and General Assembly by the end of this year. So hopefully we should be seeing that soon. There's also been rights of publicity being protected through contract. The American Federation of Musicians, who represents musicians who perform on TV and movie scores and appear on the screen, they ratified a new contract with the major TV studios in April this year, which basically states that musicians must be compensated when their work prompts AI models and ensure that human creativity remains at the heart of the industry. And this contract very closely mirrors the deal terms that were in the SAG-AFTRA and Writers Guild contracts that were won during the 2023 strikes last year. SAG-AFTRA also has a new contract that was ratified in March to protect voice actors in TV animation from misuse of AI. The agreements define voice actors as strictly human and stipulate that producers must gain permission before using an actor's name to prompt AI models. So that's on a state and contract level. There is currently the No Fakes Act, which is working its way through Congress right now. It stands for the Nurture Originals, Foster Art, and Keep Entertainment Safe Act. It was introduced in October 2023 with the stated goal of protecting the voice and visual likeness of individuals from unfair use through generative AI. This would establish a first ever federal right of publicity in the United States, and it would establish a federal property right for every individual in their own voice and likeness. There would be some exceptions for kind of like fair use considerations, like news reporting, broadcasts, documentary use, public criticism, commentary, as well as fleeting or negligible use. This right through this act would not be assignable during the life of the rights holder, but it could be licensed for up to 10 years or 5 years if you're a minor. And it would expire 70 years after the death of the individual. So, like I said, that's currently working its way through Congress. Hopefully we'll see something about that soon and something gets passed. So the big question is, how can I protect my work from AI? There's a number of ways that you could potentially protect your work. Whether or not it's actually effective is a different story. But one of those options is just opting out of a service or like social media, or just not posting. So companies gather data from a variety of public online sources that they use to then train their AI models, and that includes social media posts, videos, and images, and how companies are allowed to access and use this content for AI training lies in the terms and conditions of the platforms. And usually they grant fairly broad rights to use, modify, and share user-generated content. When you sign up for these platforms, you may unknowingly consent to these terms, which can include allowing third parties such as AI companies to access and use your data. Recently, Meta, the parent company of Instagram, Facebook, Threads, they had plans to use the content from their platforms to train AI models. And as Bill said, this all depends on where you're at. In the EU, actually, users are provided a way to opt out of this policy, but Meta has kind of made it unnecessarily complex, and it requires providing personal information and an explanation for opting out. And it is a whole process. However, if you're not based in the EU, there's very limited options to opt out of your data being used for AI training. Another recent issue, Adobe, they updated their terms of service, and the update stated that its automated systems may analyze the user's content using techniques such as machine learning to improve its services and software, as well as the user experience in general. And this very broad and vague language led its users to believe that their private and unpublished works were at risk of being used for AI training. Adobe then explained that this is not new to their terms of conditions, and it actually primarily pertains to moderating illegal content and preventing the creation of spam or phishing accounts, which has hopefully persuaded people that it's not going to be using it for AI purposes, but that remains to be seen. So like I said, opting out, generative AI models depend on training data sets. And the companies behind them are motivated to avoid restricting those potential data pools. So while you may opt out, the process may be labor intensive, like I said, with the Meta process. It sometimes includes submitting a request, providing copies and written descriptions of your images that you want to protect. And if you've agreed to let third parties license your images, the terms may also include a license for AI training. So it's worth scanning user agreements for any platforms that you have hosting your work to check what rights they hold over it. There's also anti-training tools that are out there. A couple of examples are Glaze, Nightshade, and Mist. Generally, what happens is that they run visual art through processes that is meant to confuse or block effective training. So ideally, the AI model won't learn to reproduce your work, even if it is like scraped from the internet for training. It can also block AI bots from crawling your website by adding them to a file. It's called robots.txt in a web browser. So that's another possible way. You can also include metadata, watermarking, or copyright notices, and you can embed these directly into digital files. And this can include your name, date, usage rights, any information that you may deem pertinent. And this kind of serves as an extra layer of protection, making it easier to track and prove authorship if you need to. You see this a lot in music. You see it a lot in photography. And then another option is just monitoring and tracking your work. There's tools and services that are designed to monitor the internet for unauthorized use of content, such as Google Alerts, Pixie, and TinEye. Regular monitoring allows you to be able to quickly address any authorized use. You can also encrypt sensitive data. Basically, you can't access it without a password. You can use legal tools and reporting mechanisms. In the US, you can report violations to the Federal Trade Commission. And you can also review and adjust your privacy settings, which you should do every now and then, just to make sure that things haven't changed and just to make sure that they're where you want them to be. So how can you use AI without losing protection? It can be used as inspiration and idea generation. Basically, you can use this such as kind of like a brainstorming, and you can generate unique concepts which help inspire kind of like a creative spark. You can use it, for instance, to like start a cover letter, or kind of give you a prompt to do some creative writing. You can also use it for visual exploration. So AI generated images are able to serve as like points for new creations for visual artists. They can create patterns, morph images, generate unique compositions that you can then incorporate into your work, or like suggest color palettes. It can also help with music composition. It can compose melodies and harmonies and analyze existing compositions, and generate original music ideas, which would allow musicians to experiment with new genres and styles, or like it can suggest chord progressions, for instance. You can use it for textual creativity. Like I said, you can use it as a writing prompt to kind of kickstart the writing process. Can generate sentences, ideas, and entire paragraphs and plot twists that can serve as a springboard for crafting an engaging narrative. And you can also use it to automate mundane and repetitive tasks. You can use AI to, for instance, cut and edit footage automatically image retouch, and like red eye correction for photographs, grammar style checks, translation into other languages. So it allows creators to be more efficient and focus on the core of the creating process. So what are some best practices when it comes to AI? Number one, educate yourself. You're already doing great by being here. Most creators are going to need to at least understand how to interact with AI in the future. Most professionals, even like attorneys, like we're going to have to learn how to use AI in our business in some way, shape, or form. The more you become immersed in it, the better of a position that you are in to thrive as an artist, as opposed to those who don't want to use AI because like that's the way it's always been done, basically, and refuse to adapt. So it's really helpful to start familiarizing yourself when and how to use various platforms for your work. If you're going to use AI, craft effective prompts. So you should focus on being specific and describe a subject that you want in detail. So for instance, a surreal landscape versus a surreal landscape with twisting trees, a bright orange sun, amber waves of grain, and purple mountains majesty. So being clear and concise and specific is able to lead to better results. You can include references to other works. So if you want to emulate a particular style, you can mention it by name. So like an ode to pickles in the style of Shakespeare, or a Cubist portrait in the style of Picasso. So giving references allows AI to narrow down those possibilities for the output. You can also suggest mood or emotion. So a melancholic seascape or an ethereal still alive. This allows AI to convey an emotion and provides for creative direction. It's also suggested to use open-ended phrasing, such as an abstract portrait suggesting solitude. So this gives more room for improvisation. And if you're using AI, it is best to generate multiple options. So run your prompt through AI multiple times because the results can vary even with a detailed prompt. So the more that you run it through, the more suggestions that you may get, and they may be absolutely different. We talked about it. Transform any work that you use AI to generate. Don't just use it to generate your work and then call it a day, right? So you have to elevate the level of human input. And remember, like we talked about this, in order to be protected by copyright, there has to be a sufficient human authorship to the work's traditional elements. So you can't just plug in a poem by or in the style of Shakespeare and just call it that. That does not have a human authorship to the traditional elements of the work itself. Know the platforms and how they work. We went through it earlier. There's multiple different models, and knowing how they work and utilizing multiple platforms is a way to allow you to find which one works best for your style. ChatGPT is great for writing and content ideation. HubSpot is great for content strategy. Descript is good for audio visual editing. There's a number of them out there. I use Grammarly fairly regularly, so I'll plug in my work and it will tell me like, hey, this is the passive voice, so you should change it to this. And it's just like a good way to like double check yourself. There's also art, video editing, music. There's any number of platforms out there. But if you're going to be using a platform, read the terms and conditions. They vary by platform. So like Midjourney, it's used for art a lot. Paid members own all input output that is generated. And unpaid members receive what is called a non-commercial 4.0 attribution international license. And this is basically a Creative Commons license, which allows others to share the material in any medium or format and adapt, transform, and build upon the material for non-commercial purposes. But you must give appropriate attribution. It cannot be used for commercial purposes and cannot apply legal terms or technological measures that would legally restrict others from doing anything that the license permits. And then you also grant Midjourney a non-exclusive license to the output that it creates for you. Stability AI, you own all generated content. You grant a non-exclusive license to use any image that you upload. And Stability may use the generated output to improve its services. And then like being image creator, you own all of the input and output creations, but only for personal and non-commercial use. And then you also allow a non-exclusive license to your input and output creations. Look out for mistakes. Don't skip on your research. Skimp on research. Double check facts. They're great for generating ideas and giving you a starting point, but don't assume that everything is correct. There's these things that's really big in the New York Times litigation right now, and it's called like hallucinations, where it basically like makes up something that never happened. I think a prompt from the New York Times for an article actually like gave a quote from the daughter of Steve Forbes that was never said and never appeared anywhere. And there's also like that instance of an attorney who uses AI and it made up all the case law. The case law that was cited doesn't exist. Check your content for originality. If you're going to be using AI to generate written content, check for originality. There's AI tools that are used to detect like plagiarism features, and they're specifically designed to analyze content for how much you sound like a person versus AI. But at the end of the day, create your works, right? So AI is complex and evolving, and we really don't know where it's going, but it's going to continue to become a very large part of society in any number of ways. The chances are that you're working very hard to create this amazing content and you want people to see it, but the monetary value of unseen content is zero. If you're invisible, you're not a part of public conversation. So publish your work, publish your content anywhere that your artist or your audience is able to possibly find it. And I believe we're going to go to Lonnie and then we'll do questions.
Hey guys, how's it going? Great job. Actually, there's a lot of stuff that I had no idea about that Bill and Amanda that you two expressed. Really amazing. So I mean, I'm probably not gonna talk much, but I did leave in the chat my favorite kind of platforms that I use. As an artist, from my creative perspective, the thing that I generally do a lot of is I create the pieces of artwork myself, like they're original art pieces. And I think someone asked Bill this question earlier. Typically, as an artist, my paintings are one-offs. My prints are like 1 of 11s, but I created those, right? However, I'll use AI to essentially create the marketing for it, or I just recently was asked to do this thing with Burning Man. I created this really cool visual for Burning Man. I'll show you all at the end of this. There are 2 of them I created, but I used Stable Diffusion to take my artwork and turn it into this thing that it's the color of my artwork. It moves very similarly to the way that I would have painted my artwork. It's like the moodiness of it. So, and what Bill was speaking to earlier, one of the things that I'm very, very terrified of, like as an artist, as a creative, I'm terrified of stealing someone's art. I'm terrified of, creating something that's amazing or that people love, and then eventually getting a cease and desist or anything like that. Like I'm like terrified of that. So like I try to make sure that I'm not actually creating a piece of like physical art or even, digital art that is used from AI. I think the mistake that a lot of people make that I've kind of learned over the years, I've been using like AI for years now, like pre-COVID, like the earliest like like forms of it. But one of the things that I think people don't fail to realize currently is as it's becoming more popular, AI, they think that it's similar to having a Tesla, where it's like this self-driving thing where you're like, hey, you know what? AI is going to make me rich. I'm going to tell AI to come up with this plan or make this art. I'm going to be great. And in my opinion, I don't think that's how it should be looked at. I don't think that's how it should work. I look at AI as a helper bot, right? Like it's a tool that assists you, like especially in this space for creative, like creatives are entrepreneurs. So, we essentially need someone to kind of help us. Like if you don't have the ability to pay an entire staff, that's really what I kind of use AI for the most. I've used AI to create trailers for my films. So I'm also a filmmaker as well. and I put in the chat Premiere Pro Beta. So Premiere Pro Beta is fairly new. I think they've actually made some awesome like grounds in really assisting with editing. Like I've edited so many videos through beta sound wise, like adjusted my sound levels and all these things through that. Visually, it's just a beautiful tool. And for me, I think I just really kind of delve into that space of you know, as Amanda was saying earlier, when at the end of you know, her speech, it's very important to get familiar and kind of like run your like program like over and over and over and over again. Like I don't think I've ever used like Midjourney or anything and created something. The fastest I've ever created something was maybe 2 or 3 months. So, you know, if you think about that, I probably made paintings faster, right? I can, oh yeah, you didn't see it. I can throw it on there again. But yeah, I was essentially saying that Firefly, my favorite my favorite things to use are like Firefly, Stable Diffusion, Midjourney. Here I'll throw it back there. Yeah, that's those are my favorite like basically platforms that I really enjoy using. I'll show you guys what I did for Burning Man, which is really cool. Maybe you guys will like it. But yeah, let me try to share my screen with y'all. Is that working? So here we go. Maybe you guys can see this, hopefully. But that right there, if you can see it, is this. I use Stable Diffusion to create this visual that is actually moving in the way that I actually created this art piece. I hope you guys saw that.
We're working on it on this end, Lonnie. We're trying to help you be able to share your screen. So hold on.
I'm sorry.
That's okay.
Yeah. But yeah, I essentially created that piece. And it did really well. I personally think that like one of the things I do a lot with AI is I specifically use AI as an assistant like with my work. So like if you could imagine you know, certain things like spreadsheets or things that are very technical that I personally don't have time with doing. I like to run AI. I like to run those things through AI. I've created some really awesome pitch decks and things of that nature. I think from a business perspective and a safe, just me playing it safe, like those are the aspects and the spaces that I personally use AI in regards to those things. And if it's a creation that I've made, which I actually didn't know this until Bill was speaking on that. And I'd like to actually learn more about that. But I have these pieces that I've created that I've ran through AI to make like kind of original like artworks with, where it's my piece, but it's only one of one that was generated through AI. I might have ran it through Midjourney a few times and created this thing that is more so my work. So what you were speaking on to that point, Bill, is definitely something I would like to learn more about. Because yeah, I really and there was a great analogy you made with the Mario Kart as well. So you know, for me, I think that's one of the main things that I feel like it gets kind of like misconstrued in a way, where the general public thinks that there's this tool that we have now that makes things easier, and it can and it does, but at the end of the day, like we always have to realize that as creatives, it's still like 90% we need to figure this out. It needs to be connected to us. You know, like the Damien Hirst example, if you're using a Damien Hirst or Andy Warhol to create something, that's completely different from using them to inspire your art, right? As it's very difficult in 2024 to have this original work, right? We've all been inspired by something or someone by this time. The copywriting and infringement space is a very like sticky one. Like, you know, you really never know. I feel like it's always important to ask first. But it's just one of those things. Oh yeah. Let me try to show my piece now. 1 second. So hopefully this is one of them. Can y'all see this?
No,
Really? Oh
I don't
man.
know what's going on. We're trying. We've
Oh
made
man.
you a co-host, so we should be able to share screen. I'm not sure why it's not coming up.
Same. Yeah, that is horrible. You know, yeah, that's difficult. It says that I'm sharing my screen. Yeah, it actually says that I am. That's
Is there one more button to click?
no,
I don't know.
I have literally clicked them all. I don't want to click. I don't want to click too many.
Okay. Well,
I'm gonna try removing the spotlight for a second uh, and see if that helps. And then I will just put it back again in case it doesn't work or if in case it works, okay?
Yeah.
So maybe try again, Lonnie, and see if we can see your.
Oh, I definitely how's about now? Yeah.
yes.
Yo, amazing,
Woohoo.
guys, amazing. All
How do you
right.
say
So
today?
so here's an example of me using AI to create. So I have this film that I'm working on called 25, and it's doing really amazing. We've got some really awesome executive producers behind it, thanks to the fact that AI helped me create this elevator pitch, right? So like, I think, and I'll let Bill or Amanda kind of correct me if I'm wrong. I don't want to like give the wrong information here, but I feel like things of this nature are something that you can utilize in a space that will help you out. That's not like this kind of public space where, you know, it helped me create my own concept, my own idea, and break it down into different spaces, right? So I literally used AI to create this, and that actually got me an amazing few investments in this film that I'm doing and working on, that I've been able to show throughout this kind of time. So let me find what I was looking for originally. Oh, actually, let me show you this. This is really cool. So I also used AI to create these, which it's a pen that is based off of a super large scale. It's about 8 by 11 feet. I stitched it, I cross stitched it, and I basically I created it and I made these pins out of it. So this shoe is called the Mag, the Nike Mag. And it's an art piece that I made that's cross stitched. I got to do it with Nike. This pin's gonna be released soon. I'm so glad that I'm like able to show you guys all this stuff that I haven't released yet. So I've really been wanting to show this to people. Yeah, so essentially I used AI to take my actual cross-stitched image that I had made and turn it into this. So I did it backwards in a sense. Hopefully you can all come to my studio space and check this out. I'll actually be having a show soon. Now I'll show you the stuff that I did for Burning Man. So this is one of my pieces that I used Stable Diffusion to kind of create this image. So Stable Diffusion took an art piece that I have, and it took the actual the brush strokes that I used to go through it, and it put it in motion. So the awesome thing about this piece is that at the Burning Man, you could literally kind of like it was a sensory thing, so you could walk there and make your own piece, kind of like using it's like you're merging with my art piece. So this is something that was like this amazing kind of public display of work that I had Stable Diffusion completely just break down my art into this minimalistic space for a visual element. And here is the other one that I did, which I actually really like this one a lot. I was a psychology major at Northwestern, and I also played football, and I have this really amazing photograph of a brain scan, which, by the way, guys, this is my actual brain. It's kind of crazy. So I kind of used Stable Diffusion, and then I also ran it through Midjourney to basically essentially take my art piece and the brainwaves, and at the actual show, these move at the same speed and like as the music that's being played. So it was a really awesome experience at Burning Man that I had with my art pieces. But yeah, like, you know, those are two examples of just like that. And I also like had the ability to create a film trailer using Midjourney. I'll see if I can. Yeah, here we go, guys. So I used like I used Beta to edit this trailer. This is a film that I actually got to show in a bunch of festivals like Toronto International, New York International Film Festival, Black Harvest, etc. But really quick, and this will be the last thing I show. I'd actually love to kind of talk and just, you know, have us all kind of talk and have a Q&A about different things as we can all pick each other's brains. But yeah, I'll show this trailer really quick. Which, by the way, my daughter is the star of this film.
To whom it may concern, from day one, we are taught that nothing is bulletproof outside the womb. We are shell-shocked from birth, born both a warning shot and a call to arms. What is it to be born a threat, yet impossible to protect from harm? From harm, from harm, from harm, from harm. I'm walking out in a forest again. We struggle to dream.
What do you want to be when you grow up?
Yeah, guys. So yeah, I just ran through a bunch of my work that I used AI with. There's actually a lot more that I got to utilize as well. And you know, it's really one of those situations where I feel like, you know, just like with everything else, right? As a creative, just as a human in general, like you learn through the process of figuring it out, like whatever works best for you. I fell in love with AI a long time ago, and I kind of have just become obsessed with it. You know, but yeah, I mean, if anyone has any questions for me, because I feel like I don't want to, like, you know, ramble on too much, but yeah.
That was not rambling, Lonnie. That was awesome. Folks have asked in the chat for your website. So if you could pop the link in there, that would be great. I am going to be bringing on somebody who is involved in the task force that we talked about before. So I'm going to let Richard Shavzin join us. and talk a little bit about the task force and something regarding federal legislation on AI. Richard, are you able to talk?
I think so. Am I on?
Yep, there you are. Thank you.
Great. Yeah, thanks so much. So just sort of some general background of the, so folks understand the AI task force, and the definition given earlier was absolutely right on. The makeup of the task force is at least somewhat instructive. There are, yes, of course, there are those of us who are there to ensure protections. Technically, I was nominated to the task force by the state AFL-CIO. I sit on the executive board representing SAG-AFTRA, and organized labor has 2 seats on the task force. Separate from the teachers, they have their own 2 representatives on the task force because, as I think most folks know, the nexus of education and AI is a minefield at the moment, and will probably continue to be so for some time. But in addition to that, on the task force, of course, are representatives from AI itself, in industries that are involved in AI itself, as well as those that are strong proponents of being able to use AI. So those are the forces that are all coming together to sort of to be able to craft recommendations to the legislature and the governor about how we move forward. Um, there's a couple of unintended consequences. Excuse me, as both of the attorneys talked about earlier, Illinois has some actually great protections right now. We're very far ahead of the curve in terms of state legislation right now. I went down to Springfield to testify actually on both of those bills. Um, basically the modernization of the right of publicity law from 1999 that was just passed, as well as some protections for people who are encouraged to sign away their rights to themselves, their image, voice, and likeness. And there are protections around that now, that there has to be informed consent. There has to be full disclosure of the scope of use, and the person who's being asked to sign away their rights has to have access to either legal representation or union representation. And if those 3 things are not in place, then any contract that is signed is unenforceable. It's null and void. And the really nice thing about this is that it is in fact retroactive. So if you have previously signed away your rights and you were denied those things, then basically the whole process starts over, and you're not bound by that contract. The unintended consequences part is, some of you may know that right now, for example, SAG-AFTRA is on strike against the very large video game producers, and these issues are absolutely at the core. We have been able to get agreement with some of the smaller producers. We've gotten over 80 video game producers right now, the small to medium ones, to sign on to an interim agreement. And right now we're still fighting the big ones. And the ugly truth is that at the moment, Illinois' protections, for example, are so good that if you have an Illinois address, you will not get hired to voice or do motion capture for video games, because our protections are so good. Unfortunately, that's true. Is it worth it? Sure, in the long run. So that's my sort of, spiel on this. My question, and I guess this is for either or both of the attorneys, is in terms of the national landscape, I'm wondering how the movement is for these kinds of protections nationally, because if it remains piecemeal, then it's going to be this, patchwork game of whack-a-mole, and they can just hire people who live in states that don't have these protections so they can be taken advantage of. And that dynamic will not stop for obvious reasons until there's national legislation. I do know that we've gotten inquiries from other states about some of this, but let's face it, those are, I'm going to try to be politically discreet, let's say worker friendly or unfriendly, across the landscape. And there are certain, places that would, mimic workers' rights everywhere, from textile workers in the Southeast to everything else, that they are never going to pass this stuff voluntarily. So, well, national legislation, of course, is the holy grail, and way beyond the No Fakes Act, obviously. So I'm curious if you've heard any, rumblings, or if there's any conversation about the likelihood of national legislation on this in the next, 5 years.
Yeah, don't hold your breath is sort of my advice on this. I mean, there are multiple bills that have been proposed. 2 years ago, the White House put together a bulletin on what they would like to see have happen here. Let me kind of give a little bit of context about how the right of publicity laws came up when we were talking about those kind of at the beginning, and they're very state by state. But if you look at where the states are most robust in their right of publicity protections, it's New York, Illinois, and California. And what do those three states have in common? They all have very large entertainment industries. And if you were to zoom in from there a little bit further, you would discover that indeed California's right of publicity laws are in fact the most robust and the most protective. It's interesting, right of publicity is a concept that arose really out of the creation of the photograph. And as photography became sort of more invasive in people's lives, the law invented this concept of you have sort of this right of privacy to your image. And it's a concept that really grew in fits and starts. And the original genesis of this idea was somebody snuck into a celebrity wedding and took a photo about 100 years ago. And it just completely outraged everybody that you would be so indiscreet as to do something like that. And then these laws really got kind of polished and improved in the 90s as sort of there's a proliferation of what we'll call indecent photography was being spread around, and really kind of had a heyday with the internet and the use of all that to share images maybe without consent. And now we're seeing this with AI. And so I think the optimistic take for like a national AI law is that, unlike right of publicity, which really kind of inflicts its most pain on celebrities and therefore the most protections on celebrities, AI is something that affects people fairly broadly in the use of their creations maybe being misused. And so I think probably the argument for hopefully seeing some bipartisan support for getting something done, because that's the only way anything will, is to see sort of that momentum grow right there. The flip side is we never got there on right of publicity, and we're still not there on like a true data privacy law either. So, I'll stick with let's not hold our breath. But that's sort of the momentum that you would want to see. And I think, Richard, to your point, the fact that there are multiple states that are looking into this, so the fact that I think a lot of states, even if it's not as worker friendly as some of us might prefer, that a lot of states think that this is a major issue that they need to address. That's the sort of thing that may help push federal legislation forward.
Yeah, the one thing I'll just jump in to say, thank you for that. That was actually really helpful. Is that an example of exactly what you were just talking about is Tennessee, a state you mentioned earlier that's not particularly known for its, progressive legislation, certainly in terms of worker protection. However, because of Nashville and the music industry in Nashville, on that one particular issue, we are in touch with and have had some of this championed by people who in any other context would not be on that particular side of the issue. So there's a certain amount of realpolitik that is obviously in play here.
Yeah,
Yeah.
and building on that point. Sorry, go I mean, just building on that point, that's an opportunity for creatives to really assert some political influence. I mean, this is an area that matters. I mean, actually, if you go back and you look at when did Illinois enact theirs, there was a guy named Michael Jordan who had the number 23 misused by a grocery store, and suddenly Illinois got very interested in right of publicity protections for people. So this is a thing where one person makes a difference. I think Amanda's going to jump in with some skepticism, though.
Yeah, no, I'm just so like I agree with Bill. Like, let's not hold our breath about anything soon. But I mean, it's worth noting that the No Fakes Act is a bipartisan bill. Everyone is very aware that this is an issue. The No Fakes Act doesn't only protect celebrities, but it protects everyone. So I do think that we're moving in the right direction regardless of like how quick it may be. And so I'm actually a part of the Recording Academy, and in October we have what is called Music Advocacy Day, and people meet with their Congress people to discuss issues in music that we would like to see. And this year it's all about AI protections and the No Fakes Act. So it's a very real issue that is being discussed. The problem is that the law moves slowly and technology moves at a much faster pace.
Well, we're a little bit over, but we do have a question that's sitting in the chat, so I want to make sure that we do address that. So we've got, I think it's Penny, who has asked, why would an artist come into the gallery where I work and ask for us to sign a non-disclosure and or permission of use of their AI imagery and their ideas? Seems a bit strange, and I will not sign anything. I work at a not-for-profit. Any thoughts?
Sorry, can you read that back one more time?
Sure. It says, why would an artist come into the gallery where I work and ask for us to sign a non-disclosure and or permission of use of their AI imagery and their ideas?
Well, so I think an artist would do that because copyright law, they're concerned that copyright law isn't protecting them the way that we traditionally would think of it as doing. I would like a little bit more information about like what's going on here exactly, because like obviously the point of displaying the work at the gallery is to disclose it. So that seems a little bit awkward, but I think that probably would be stemming from a concern that since my work's not necessarily copyrighted, and Lonnie threw out some really interesting works that I think largely are copyrightable. This is like a new step or an extra step they're trying to take to try and create some sort of protection around that. Devil's in the details, and I can't really give you legal advice on whether or not that works or not, but I suspect that's where the thought is going.
Yeah, and just to shout out, our partners, Lawyers for the Creative Arts, is part of our team of putting together these webinars. So please feel free to reach out to them when you are looking for some legal advice like this. So we don't have any other questions pending. This has been an amazing conversation. Thank you, Richard, for being our special guest at the end. So I want to thank all of our speakers and everyone for spending your morning with us. Carlos, my teammate, is going to drop some links into the chat. So if you do have some questions that come up later, you can send them to us through our help desk, which is artsalliance.org/support or help@artsalliance.org. We've also been noting that the recording of this program will be on our YouTube page shortly, and you can find the recordings of our past programs there. Our YouTube is youtube.com at Arts Alliance Illinois. And really important is that we want your feedback because we want to make sure that we're providing the programming that you're looking for. So we'll be popping a link to our survey into the chat. So if you can grab that before we sign off and give us your feedback so we can improve our programming for you. And then to make sure you stay on top of everything that Arts Alliance is doing, all of the offerings that we have, please sign up for our newsletter, artsalliance.org/signup. So that's it. Those are all the links I have. Thank you again to everyone. This was really cool, and we look forward to seeing you all at a future Help Desk program in 2 weeks. We are doing our program for nonprofits, and looking forward to seeing you all then. Thank you so much, and enjoy the rest of your day.
Thanks, everyone.
Bye-bye.
Yeah, thanks, y'all.
Thanks.